Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Well, we're going to get to talk about the state of New Jersey again. Now, listen, I always say when it comes to absolutely the worst gun laws in America, look no further than California. And if you want to find the most evil gun laws in America, look no further than Illinois. But if you absolutely positively want to find the most idiotic gun laws in America, well, that's when you need to go to New Jersey. Did not realize this until I found this case right here, which we're going to talk about today, that New Jersey actually bans self-defense ammunition. That's right. They actually ban hollow point ammunition. Now, I'm not going to get into the reasons why you should be carrying hollow points versus full metal jacket ball ammo. There's plenty of other people out here on YouTube that can explain that, but I can explain just how dumb this law is and why it needs to go. So today, let's spend a few minutes and let's talk about the law that limits self-defense and why it's time to be overturned. Okay, hey, before we get going too far down the road we're going down, let's remember that this video is being brought to us by our good friends over at the Sonoran Desert Institute. That's right, get ready to launch your career in the firearm industry today through education. Get ready to start arming yourself today through education. And most importantly, get ready to start defending the inalienable rights of millions of Americans nationwide, all through our most powerful act, which of course is education. Listen, the Sonoran Desert Institute has a degree, a program, or a certificate for just about anything that you may desire. So for more information, check them out in the description box below, or easier yet, just visit them at sdi.edu. Okay, America, the case we're talking about today has been filed in the United States District Court for the District of New Jersey. It is the matter of Bergmann-Schoch v. Platkin. Now, if I am mispronouncing that last name of the plaintiff, I do apologize. This is a challenge to New Jersey's law, which bans hollow point ammunition, jacketed hollow points, or what we like to call self-defense ammunition. The complaint, which we will be reciting today, starts off as follows. This case involves a challenge to New Jersey's unconstitutional and ahistorical ban on the possession, transportation, and carrying of widely available and commonly owned hollow point self-defense ammunition, which New Jersey calls hollow nose or dum-dum ammunition. So, New Jersey, not only do you have a stupid law, you have a stupid name for ammunition, which is simply just jacketed hollow point. Now, a lot of you may be sitting there going, wait a second, how can they do this post-Bruen? That's an excellent question, one that the plaintiffs begin to outline in their complaint. Rejecting the principles of Bruen, New Jersey forbids a person from publicly possessing the most effective types of self-defense ammunition, despite the hollow point's overwhelming popularity with law enforcement and armed citizens alike as the quintessential type of self-defense ammunition. Now, I get some of you are going to start putting comments down there in the description box. Well, I don't use that for self-defense. Hey, I don't really care, okay? Because it's not germane to this discussion. And if you want to have a real good geek out session about why you should be carrying hollow point versus ball ammo for self-defense reasons, there are 1,000 other channels out here on YouTube that can handle that issue for you. But you did spot the problem, which is, where's the history to support a ban like this? And as the plaintiffs point out, in addition to defying the widespread preferences of the American people, New Jersey's ban is also ahistorical. While the hollow point was first introduced in the 1880s, New Jersey's ban came nearly a century later in 1978. Today, New Jersey remains the only state to criminalize the bearing of hollow point ammunition. Oh yeah, and in New Jersey, don't try reloading hollow points, because the plaintiffs also point out New Jersey's ban on hollow point ammunition applies to both handgun and long gun ammunition, including the component parts thereof. And like I say, if you talk to any competent firearm instructor, they will explain the thousands of reasons why you should be carrying jacketed hollow point ammunition for self-defense, which of course, since the plaintiffs are aware of that fact, they point out, consequently, New Jersey bans public possession of what is quintessential self-defense ammunition in a handgun that is the quintessential self-defense weapon. All, of course, which would be in violations of rather clear holdings in Heller. Now, circling back to the Bruen case, I know a lot of you are like, there is no way that this law could withstand a Bruen analysis. You're right, there is no way, unless, of course, the New Jersey court cooks the books on this one. But as the plaintiffs very wisely point out, when it comes to this type of analysis, the types of arguments that New Jersey is going to make, well, we need to do this to save lives. These are cop killer bullets and things like that. Okay, none of them are going to fly because Bruen foreclosed those types of considerations. In other words, according to the Second Amendment's text, as elucidated by the court in Bruen, if a member of the people wishes to keep or bear a protected arm, then the ability to do so shall not be infringed. It does not matter at all how important, significant, compelling, or overriding the government's justification for or interest in infringing the right, nor does it matter whether a government restriction minimally versus severely burdens or infringes the Second Amendment. There are no relevant statistical studies to be consulted. There are no sociological arguments to be considered. The ubiquitous problem of crime or the density of population do not affect the equation. The only appropriate inquiry then, according to Bruen, is what the public understanding of the right to keep and bear arms was during the ratification of the Second Amendment in 1791. That is a very clear enunciation of the rules of Bruen, and of course what the public's perception was of the Second Amendment was not that certain types of ammunition, especially that which is specifically designed for self-defense, could just be outright banned. Now, we know the state of New Jersey is going to sit there and go, yeah, but when the founders ratified the Second Amendment, they had no idea that there'd be these types of firearms and this type of ammunition. And we've talked before about how when they ratified the First Amendment, they didn't have any belief that there would be the internet either. But it does not mean that the First Amendment doesn't supply protections there, as the plaintiffs wisely point out here. With respect to the term arms, the court explained the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding, and that general definition covers modern instruments that so much as facilitate armed self-defense. In other words, the right to keep and bear arms presumptively applies to all Americans, presumptively extends to all bearable arms, and presumptively covers all locations. Anything limiting that expansive reach must comport with a broad and enduring historical tradition, demonstrating that certain persons, arms, or activities were never considered within the scope of the Second Amendment in the first place. And then, of course, the state of New Jersey likely is going to argue, well, they may have a right to keep and bear arms, but it doesn't say anything about ammunition, which I know all of you are throwing up in your mouth right now just hearing that argument. How did the plaintiffs deal with that? Bullets and ammunition for firearms unquestionably are arms under the Second Amendment's plain text. As the Heller Court observed, the term arms was originally understood to mean anything that a man wears for his defense or takes into his hands or useth in wrath to cast at or strike another. Hollow point bullets are quite literally a thing cast at and which strike another, being projectiles which are fired from firearms in self-defense. Thus, just as previous generations understood bows and arrows to be arms, so too are firearms and bullets today. And then, of course, we only have a historical tradition of banning items which are both dangerous and unusual, but we are talking about jacketed hollow point ammunition. There is absolutely nothing unusual about that, and therefore the plaintiffs point out, consequently, hollow point ammunition is in common use, and being a flat ban on bearing a type of arm is subject to the very same Heller-style per se invalidation that Heller levied upon a flat ban on keeping a type of arm. And candidly, finding that ammunition is not covered by the Second Amendment essentially eviscerates the Second Amendment, doesn't it? Well, yeah, it does. And the analogy that the plaintiffs use, a contrary conclusion that the Second Amendment protects firearms but not ammunition, is akin to holding that the First Amendment protects paper but not ink. So we know what the problem is. What technically is the legal issue here? Well, I think the plaintiffs sum it up really well like this. New Jersey law compels citizens to choose the inferior option for self-defense outside the home. Indeed, dating only to 1978, the law generally bans possession of hollow nose or dum-dum bullets. And any argument that, hey, citizens just simply can't be trusted with hollow points. I mean, we can trust them with all the ball ammo in the world, but not the hollow points. The plaintiffs correctly point out that, hey, you know what? These are all firearm owners, which means they've already been through background checks, as they put it. And because New Jersey broadly bans the unlicensed carry of handguns outside the home, individuals who wish to carry hollow point ammunition in their firearms must be licensed by New Jersey to carry with a permit to carry a handgun. This means that the individuals who would be carrying firearms loaded with hollow point ammunition already have been vetted by New Jersey to be among the most law-abiding citizens in New Jersey. And this law absolutely, positively, and without a doubt infringes upon and impairs the ability for people to defend themselves. There is No debating that. And as the plaintiffs point out here, in any event, hollow point ammunition is preferred for self-defense because it is designed not to overpenetrate the intended target and is more likely to stop a threat faster and with fewer shots than ball ammunition. These are some of the reasons that the citizens across America choose hollow point ammunition for the firearms they carry for self-defense. Okay, and then finally, you guys know this because you geek out all the time on this channel, remedies. We need remedies. If you have a lawsuit but you don't have a remedy, you don't really have a lawsuit, do you? What specifically are the plaintiffs asking for? 1, an order declaring that the challenge provisions are unenforceable, unconstitutional, and violate the 2nd and 14th Amendment. 2, an order permanently enjoining defendants and all other officers, agents, servants, employees, and persons under the authority of the state from enforcing the ban on possession, transportation, and carrying of enumerated types of self-defense ammunition outside the home. Listen, this is an incredibly well-drafted complaint. It is brought to us by our good friends at the Gun Owners of America, which means, yes, that's right, there's a link down below so that you can show them some love. The case, once again, is Bergmann-Schoch v. Platkin. We're going to link up the complaint down below so that you guys can geek out on it for yourself. We're going to pay very careful attention to this very, very important lawsuit. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do all of that is right down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.